we are discussing, that is law of contract, and under law of contract in this video we will be discussing the discharge of contract. So under this heading we have mode of discharge of contract that we will discuss, that is discharge of contract by impossibility of performance. See, the meaning is integrated, or that is something like clear in the term itself, that is impossibility of performance. So if certain contract of such type that somehow because of unavoidable reason it became impossible to perform, then that contract will be discharged, okay, automatically, you can say like that. No need to something like do some obligation, maybe you can or you cannot, but that is understood, okay. So now let's check the technical meaning. In a condition when performance of a contract becomes impossible with or without the knowledge, see, with or without the knowledge of the parties to the contract, the contract is said to be discharged. So in this case, certain kind of act that may be speculated, but certain act that may not be speculated, in both the condition, if performance of that obligation created through the contract becomes impossible, then the contract said to be discharged. Some of the possible reasons of such conditions may be destruction of the subject matter. What does it mean? That destruction of the subject matter. Your friend come to you and both of you agreed that you will buy his bike, okay, because he wanted to sell that bike and he approached you, so you agreed upon that you will buy his bike. He said that tomorrow I will come and deliver the bike, okay. What happened? While returning back, your friend met with an accident and the bike damaged badly. So in this case what happened? The subject matter, the subject itself destroyed. So the contract that you made with your friend, that's supposed to be discharged, okay. So there is no obligation anymore. Now the next one is death or incapacity of party. What does it mean? That if you contracted with B and somehow before performing that obligation B died or became insane, so again in this condition to perform that obligation become impossible, so contract will be discharged. The next one is non-existence of a state or things having an effect directly or indirectly on the contract. What does it mean? That you contracted something that is already gone, there is no existence of that thing that you contracted. In such a case this contract is void, okay, and supposed to be discharged. The next one is outbreak of war. What happens? You made an agreement, say with the neighbor country, and in the middle of or after your contract that is signed, what happened? Between both the countries the war started, so now that country became enemy. So in this case this contract became impossible to perform, okay, so it is discharged. The last one is change or amendments in law. Well, this is very conceptual kind of thing, though everything is conceptual, but it is interesting to understand. Of course, see, as always I say, the law is the matter of the thing of a spatio-temporal kind of So what is meaning of a spatio-temporal? A spatio-temporal means certain law at one place it is legal, but at some other place it is illegal. Take the example of alcohol. Alcohol in India, in certain states, it is allowed to drink and do the business of alcohol. But in certain states, it is prohibited. So, at the same time, at two different places, there are two different laws. Fine, so it is a spatio. Temporal, it means something like today the kind of law, the kind of act basically is legal. It is possible that become illegal next day. Okay, so in today's world it is legal, but in the future that may be illegal. Take the example of alcohol again. In Bihar, a few years back, the alcohol is legal, but these days it is illegal. Okay, so it is a spatio-temporal concept. Now come back to this provision, that is change or amendments in law. So take the example again of alcohol. Okay, in Bihar, two persons contracted with the person who is doing the business of alcohol in some other state, and the person from Bihar demanded 2 trucks of alcohol. Okay, and the other person who is supposed to deliver that contract or that alcohol that committed to deliver after a month. Okay, in the middle of that, law changed. So it is no more allowed to do the business of alcohol in Bihar. So in that condition, the contract is supposed to be discharged, because law doesn't allow means you cannot do the business of illegal object. Law object has to be lawful. Even in contract, we have studied one of the principles of contract, that is lawful object. So in this case, it became unlawful. So it is discharged. Now, see some technical aspects of that. Though we have understood the meaning of this mode of discharge of contract, but nevertheless something detailed. That is, as section 56 states that an agreement to do an act impossible in itself is void. So certain kind of agreement that is you made in itself impossible to perform, that is void ab initio. For example, understand it with an example, you might get confused. That is, A agrees with B to discover treasure by magic. See the kind of language. A agrees with B to discover treasure by magic. The agreement is void. Is it possible to discover the treasure through magic? So such kind of contract is void ab initio. A contract to do an act which after the contract is made becomes impossible, or by reason of some event which the promisor couldn't prevent, unlawful, becomes void when the act becomes impossible or unlawful. Okay, so this is clear. Nevertheless, see the example that here given. A and B contract to marry each other before the time fixed for the marriage. A goes mad, the contract becomes void. So while making the contract, both the persons are fine. But after certain days and before the marriage fixed, one of the parties gone mad. In this case, contract is supposed to be discharged, because the possibility to perform the contract become impossible. Next point is where one person has promised to do something which he knew or with reasonable diligence might have known, and which the promisee didn't know to be impossible or unlawful. Such promiser must make compensation to such promisee for any loss which such promisee sustains through the non-performance of the promise. Well, this is again complicated but very simple. Believe me, this definition is very simple. It is simply saying that you and your friend making an agreement. Okay, your friend said that he will give you his bike, okay, and you will pay him the money. Fine. Okay, so what happened? But your friend from whom you are buying the bike, he knows that the bike he was selling, that is not a something like legal, in the sense that that doesn't belong to your friend. Rather, that was the bike that is stolen from somewhere, and he created some fake document and all, and now selling to you. So the object is unlawful because that is not a valid object, in the sense that is not genuine because it is not of your friend, rather it is a stolen property. So in this case, if you bought the bike from your friend and later on you come to know some police case and all happen, in that case whatever the loss you suffered, that will be given by your friend. Okay, so this is saying something like that. Okay, so now check out the example. A contract to marry B, being already married to C and being forbidden by the law to which he is subject to practice polygamy. A must make compensation to B for the loss caused to her by the non-performance of his promise. Well, of course, I have given the example of bike. This is another example that a person, namely A, promised C to marry with her, and A already married. C doesn't know that A is married. In this condition, whatever the loss C will suffer, that will be given by A, because polygamy is not allowed. So he cannot legally marry with C. Okay, but in this case the damages that has to be given by the cheater one, the party who has the bad intention. Okay, so this is all about the discharge of contract by impossibility of performance.